All right, ladies and gentlemen, it seems to be that time. I am Professor Michael Scharf, the director of the Cox Center, and it is my pleasure to reintroduce you to your beloved dean, Bob Rawson, who will be introducing our speaker today.
Beloved is not an adjective I normally associate with myself, so I'm grateful to have that perspective from Michael. I'm delighted to have the honor today of welcoming you to our annual Klatsky Seminar in Human Rights. This seminar is a feature of it's a series that was launched in 2001 with a generous endowment from Bruce J. Klatsky, who was the chairman and CEO of Philips Van Heusen Corporation and a member of the University Board of Trustees. This endowment not only provided the means to support an annual distinguished lecture, but also has funded the annual summer fellowships for our students at Human Rights Watch in New York City and Washington, D.C. Not only that, the endowment has been very significant and important to us because it essentially has kicked off what has grown into a robust and innovative human rights program here at the law school. We've hosted several major conferences and expert meetings on human rights topics during the past few years. Our professors have trained judges in human rights law around the world, and our students have drafted over 200 research papers and memos for 6 international war crimes tribunals. The centerpiece of the whole program, of our human rights program, continues to be, however, the annual Klatsky Lecture, which has featured such luminaries as Judge Christopher Greenwood of the International Court of Justice, Chief Prosecutor Richard Goldstone of the International Criminal Tribunal for the former Yugoslavia, Executive Director Kenneth Roth of Human Rights Watch, and Pulitzer Prize-winning author Samantha Power. And we are privileged today to have as our speaker someone who belongs in the ranks of those persons I've just named. Professor Philippe Sands is one of the world's foremost scholars and practitioners in the area of human rights. He is a professor of law and director of the Center on International Courts and Tribunals at the University College of London. He is also a barrister at Matrix Chambers, and in 2003 was appointed Queen's Counsel. He has published 14 books, including the acclaimed and provocative Torture Team, Rumsfeld's Memo and the Betrayal of American Values. As a practicing barrister, he has extensive litigation experience on top of his academic reputation and experience. He's appeared numerous times before the British High Court, the European Court of Justice, the European Court of Human Rights, the International Law of the Sea Tribunal, the World Trade Organization Appellate Body, and he has been counsel in 11 cases before the International Court of Justice. His lecture today reminds us of the importance of individual international lawyers in the shaping of world events. He will discuss the unprecedented contributions of 3 such individuals who happen to be living in the same city in the Ukraine in the early 1900s. Please join me in welcoming Professor Philippe Sands.
Thank you very much, Dean, and thank you also to Professor Scharf and to all the colleagues who've made my trip here so enjoyable. It's actually the first time I've been to Ohio, but I feel like I know Ohio well because I happen to be married to an American who studied as an undergraduate at Oberlin. So I've heard a lot about Ohio, and it's very nice in particular to see some of her friends in the audience. Last summer, a curious thing happened to me. In preparation for my visit to deliver an earlier version of this lecture in the now Ukrainian city of Lviv, I was introduced to an elderly lady in Paris. I had told a friend about my trip to the Ukraine and was delving with increasing frequency and fervor into the history of that city. My friend said, "You should visit my relative Inka. She lives in Paris. She lived in Lvov from 1930 to 1945, and she can tell you what it was like." So I called Inka by telephone, and we agreed that when I was next in Paris, I would visit her. And in June of last year, we met, and she told me her own personal story, which is a remarkable account of survival and of loss and of renewal. And she is a remarkable and courageous individual who seems undimmed by the brutality of her own experiences. But for present purposes, let me just share one aspect of my visit with her. We were sitting at her dining room table, which was covered with a beautiful old white tablecloth, drinking what I think would now be called Russian tea. On the table, I'd laid out an old map of Lviv, dating back to 1938, which was where Inka lived as an 8-year-old. And I also had a few copies of old black and white photographs of the city and the surrounding environments. One of the photographs was of a building in a small town called Zolkiev, which is about 20 miles from Lviv, a picture of a famous old synagogue that was constructed in the 17th century and that is still standing today, although pretty dilapidated. Inka had told me that after the war, in 1945, she had lived for a few months in that small town of Zolkiev. I asked her whether she remembered the building, and I gave her the photograph of that building. It was actually an old postcard dating back to the first part of the 20th century. She looked at it very carefully, and she said, "No, I don't remember this building. I don't think I've ever seen this building before." Now, she was holding the picture very close to her face. Her doorbell rang. She lives on the upper floors of a Paris apartment block. She raised herself, went over to the front door of her apartment, opened the door, and it was the concierge. As you know, in Paris, apartment blocks have elderly ladies who watch people coming in at the bottom and keep an eye out, sort of spies. And she had the mail, and she handed over a single letter. She looked at the letter and said, "I don't know what this is. Looks to me like it's for you." That was very odd. I'd never met Inka before. I'd never been in that apartment. She gave me the letter, which was addressed to her. And it came from Israel. It was from a body that called itself the Associations of the Martyrs of Zolkiev. I opened the envelope, and inside the envelope was no letter but a brochure. And on the front of the brochure, astonishingly, was the very same picture that she and I had just been looking at her table. That left us, of course, rather surprised. It was an instance of memory and of coincidence. And as we all know from our own experiences, memory and coincidence are very curious and sometimes troubling things. They appear occasionally and unexpectedly, and when they do, they get us thinking about the present and about the past. And even if we can't find a pressing or persuasive explanation as to what has happened, what we remember and what we don't, we just don't know why things like that happen. We speculate, but we don't know. These things hover around us. Lines are drawn, connections are made, they may be imaginary, they may be real, perhaps they're both. And in preparing this lecture today, I've thought back to that moment of coincidence between my showing a picture to Inka Katz and that picture then appearing in a letter a few minutes later. I've asked myself about the photograph, about what these coincidences mean, about the life that she left behind in that town, and about the state of the world today. A few months later, I visited Lviv. It was in October. It's more than 2,000 kilometers from my home in London. I was invited to give a public lecture about my work in international law. It's a country I had never visited before. The place I was going to was a seminar at the University of Lviv's Faculty of Law. And you might ask yourself what possible conspiracy of circumstances would have caused an invitation to be extended to me, and why would I accept such an invitation? For the moment, let me just say this. The reasons I accepted the invitation are personal, and they're not entirely disconnected from the city's unlikely, but it now is clear to me, largely unknown contribution to the modern system of international law that many of you in this room are studying. So why was I invited to Lviv? Why did that faculty invite me? I'm an international lawyer, and I wear two hats. Half the week I'm an academic. I teach law at University College London. I teach classes about human rights, about the environment and natural resources, about international courts and tribunals. I write books, I write articles. The other half of the week I practice as a barrister, and I'm very privileged indeed to be an advocate who appears before courts about which I teach. I argue cases at the International Court of Justice and at other international courts and tribunals. These cases in which I'm involved and which I also write about invariably raise issues about the rights of states and increasingly the rights of individuals. And they reflect the dramatic changes that have taken place in the international legal order over the past 5 or 6 decades, in particular since the end of the Second World War. The legal order which we live in today is characterized by 3 essential features. Firstly, the rights of individuals have been recognized, in particular in relation to human rights. Secondly, the emergence of a new field of international criminal law with which this law school is closely associated. And third, the creation of new international courts and tribunals, a great number of them now, which provide fora for the settlement of international disputes. Put simply, the world of international law in which I work every day did not exist before the Second World War. So for me, a typical working week is immensely varied. I could spend a couple of days advising Croatia, for example, on its case at the International Court of Justice, brought under the 1948 Convention on the Prevention and Punishment of Genocide, which was the first modern human rights treaty adopted after the Second World War. That convention prohibits genocide and commits states to prevent and punish any acts of genocide. The convention gives the International Court of Justice an enforcement role. In 1999, Croatia brought proceedings against Serbia, accusing it of having committed genocide in Vukovar and other parts of eastern Slavonia, and Serbia has now brought a counterclaim against Croatia, alleging the same thing in different parts of that Balkan region. Then, the next day, I might spend time on other issues of international crime. This week, for example, it's been the question of whether a lawyer who authorises an act of torture can be complicit in the commission of an international crime. The fact that such an argument could even be made plausibly today arises from the adoption by the United States, the United Kingdom, the Soviet Union and France of the Charter of the International Military Tribunal of Nuremberg on the 8th of August 1945. That's, of course, better known now as the Nuremberg Charter. Article 6 of the Nuremberg Charter recognized that certain acts, and this was path-breaking and revolutionary law, certain acts, crimes against peace, war crimes, crimes against humanity, are so heinous that they give rise to individual criminal responsibility, and that no one will be immune from the jurisdiction of the tribunal, even a head of state. These principles in the Nuremberg Charter led directly to the emergence of the modern system of international criminal law. And, for example, the rules that meant that a case could be brought against Senator Augusto Pinochet of Chile in the London courts. They also gave rise to the ICTY and the proceedings, for example, against President Milosevic, a serving head of state, and also the adoption in 1998 by some 200 states of the Statute of the International Criminal Court. Those 3 events all occurred in 1998. None would have been possible but for the events of the 1940s. And then, to end the week, I might spend some time on maritime issues, on the fascinating cases, for example, that occupy me right now, concerning the delimitation of the boundaries of the Bay of Bengal, advising on 2 cases brought by Bangladesh, for whom I act, against, respectively, India and Myanmar. That such work is possible, that I could spend any time litigating those kinds of cases, is due to the adoption of the 1982 United Nations Convention on the Law of the Sea, a charter for the oceans, which also provides uniquely for the possibility of binding dispute settlement before bodies like the International Tribunal for the Law of the Sea in Hamburg or international arbitration. These 2 institutions are illustrative of the new modern approach to international law. Now, I mention my involvement in these cases, which I'm privileged to be involved in, simply to make the following point. The life of an international lawyer today is constructed upon foundations that were put in place after the Second World War. Without those rules, without the law of the Sea Convention, without the modern system of human rights law, without the new international rules on criminal law, my working week would be completely different. There's another reason that I mention these developments and the work that I do. Each of these juridical developments, and many others, are intimately connected to this city of Lviv in the Ukraine in ways that have never previously been understood. For the students in the audience, let me say something briefly about becoming an international lawyer. It should be encouraging. I grew up in North London in a family that was middle class that had no lawyers in it. Home was not intellectual, not academic, and as I've mentioned, not in any way legal. There's never been any lawyers or anyone associated with law in my family. I went to university in England, to Cambridge, to study economics, but I benefited from a wonderful economics teacher at my high school, with whom we'd covered much of the first year university syllabus. So I decided to change to law, which in England is an undergraduate course. I didn't particularly enjoy, I have to say, the study of law, learning about cases on contract and on tort in a way that seemed totally disconnected from the underlying political, social and economic realities that caused particular rules to be adopted and enforced. But I did have one professor who made a real difference, whose classes I really enjoyed. His name was Robbie Jennings, and Professor Jennings was a Yorkshireman who taught the course on international law. In fact, it was the last course he ever gave before he became the British judge at the International Court of Justice in The Hague. And his lectures were different, not so much because of the quality of the delivery. Remarkably, I remember he delivered every single lecture over an entire year without ever having a note in front of him, but because of the subjects he addressed. His lectures were about war, about boundary disputes, about maritime issues, about human rights, and about other matters on which the imagination, my imagination, could become somewhat excited, taking us out into the world to exotic places with a propensity for conflict. Although I was English and am English, I have a French mother who was born in Vienna in 1938. So in some way, Professor Jennings' lectures connected to a personal experience, something others in this room will also, I think, have appreciated. So I added an extra year to my studies after I finished my undergraduate course to do more international law, a subject that I enjoyed. In 1983, I got a specialist degree in public international law, which is absolutely indispensable if you're truly committed to the subject. And then I followed my heart and went off to America to be with my then girlfriend, a different American girlfriend, a neuroscientist for my friends in the audience, and spent a year living in Cambridge, the other Cambridge, Massachusetts, spent a year in Harvard. I remember the week that I arrived very well because it was the week in which the Soviet Union shot down a Korean airliner in 1983 in October. And in fact, that event became the subject of my first ever academic article. I turned up at Harvard with a place to live, my then girlfriend, but really nothing else. I went to the law school to see if someone needed a research assistant on international law and was incredibly lucky to chance upon a young academic, newly appointed, called David Kennedy, who had been appointed to the Manley Hudson Chair of International Law at Harvard Law School. He, in fact, had succeeded a very distinguished international lawyer, Professor Louis Sohn. David needed research assistance. He needed someone to help with his footnotes, and I was happy to do anything for $12 an hour, and he hired me. He also got me an appointment as a visiting scholar at the law school, and I spent a fabulous and intellectually challenging year as part of a very vibrant academic community that really changed the way in which I looked at law and the relationship between law and politics and society. And then the next spring, I was still living in Cambridge, Mass. In April 1984, out of the blue, I received an unexpected letter. A letter came from Cambridge in England. I remember it well. It was in a sort of blue-grey envelope. It was on that very sort of heavy paper that has a reassuring sort of authority to it. I remember getting the letter very well. And the letter simply informed me about a new research centre on international law that was going to be created at Cambridge University. And the writer was looking to appoint a junior research fellow for a period of 4 years. Was I interested? The letter came from one of my international law lecturers, Mr. Hersch Lauterpacht, who I'd come to know a little bit, but not very well. I responded positively, I would be interested, and late that summer I got an offer of employment, my first job ever. Very exciting. It came with a room, free meals at St Catherine's College, Cambridge, and the salary of £1,000 per quarter, about $1,500 per 3-month period. And I was completely thrilled. And with that began my career in international law, a quarter of a century ago, in the autumn of 1984. Over the years, I eventually moved to London and qualified as a barrister, again with the encouragement of Hersch Lauterpacht, who had become something of a mentor for me. My main focus in those days was on the environment and on natural resources before they became fashionable, but even that was accidental, or at least the result of an accident at the Chernobyl nuclear power plant in April 1986, coincidentally in the Ukraine, which plant, as you know, exploded and caused tremendous damage and concern. From that accident, I then got an invitation from the United States to deliver a lecture on the subject of transboundary air pollution, a matter that was not, in the mid-1980s, it has to be said, particularly well developed in international law. And Hersch Lauterpacht encouraged me to go. That lecture then became the subject of my first book on Chernobyl, which came out in 1988 and catalysed an abiding and continuing interest in the environment in international law and led to my first treatise, which was on principles of international environmental law, which came out in 1995. And right now I'm working on the 3rd edition of that. From that came invitations to act as a consultant to various non-governmental organisations like Greenpeace and Friends of the Earth and Amnesty International. And I became increasingly interested in the role of non-state actors in how international law was made and how it was enforced. My work as a barrister, by then I'd qualified, also began to take off, and I appeared for the first time as counsel before the International Court of Justice in 1995, a bizarre case, an advisory opinion on the legality of the use of nuclear weapons. In July 1998, I participated on the delegation of the Solomon Islands in the final negotiations in Rome that led to the adoption of the Statute of the International Criminal Court. And that same year, 1998, rather remarkable year, I was involved in the litigation before the English courts, including the House of Lords, on the question of whether Senator Pinochet was entitled to claim immunity in respect of allegations of involvement in torture in Chile in the 1970s and the 1980s. In fact, in March 1999, as many of you know, the House of Lords handed down a landmark judgment, maybe one of the great judgments of the 20th century, in which it said there could be no impunity and no immunity for a former head of state, a clarion call for the rights of victims and of individuals under the new international legal order. And around that time, I became a professor at the University of London. Following year, on September the 11th, 2001, I was teaching at NYU Law School when the attack on the World Trade Center took place about a mile away from the classroom where I was teaching, leading, of course, to the wars in Afghanistan and Iraq and the use of torture by Western powers, in particular the United States, possibly supported by the United Kingdom. And I wrote 2 books directed to a broader audience. As international law issues gained ever more traction, interest in international law grew. In 2005, Penguin published my book Lawless World on the illegalities of the war in Iraq, on the treatment of detainees at Guantanamo, and on how Tony Blair and George W. Bush became serial violators, in my view, of international law. And then 3 years later, in 2008, Penguin published a second book, Torture Team, an indictment on the role of the Bush administration lawyers in authorizing torture. And I get here to the point. At the heart of that second book, but also of the first book, were the rules of the Nuremberg Charter and the Geneva Conventions, rules that the United States had done so much to put in place. Coincident with these writings, I became increasingly involved in litigation before various courts in the defense of rights of individuals who alleged they'd been subjected to abuse and torture in violation of these new rules of international law. So, in broad brush, these are the lines that run through my work on international law, in my academic work and in my practice. The rights of individuals, the limits on the power and authority of the state, the role of international courts and judges. And the question I've often asked myself is this: what drew me to these areas? Why did I become involved in these areas? Now, for all of us, we ask ourselves why we do what we do. It's never an easy question to answer. No doubt a consequence of nature and of nurture. But I've now come to the conclusion that in a curious way, there is a connection to this Ukrainian city of Lviv. In 2008, I received an invitation from the World Economic Forum, organisers of the well-known Davos meeting, to do some work for them on international law, working with a lady by the name of Oksana Mishlovska, a young Ukrainian lawyer who happened to come from Lviv. That's interesting, I said, digging deep into family memory. I think my grandfather was from Lviv. Until that conversation with Oksana, relatively recently, I'd not given much attention to this part of my family history. I was very close to my grandfather. He lived in Paris, I lived in London. I didn't see him that often. And he'd lived a life about which questions of the past were not only not encouraged, they were disallowed. He would say to me, "We must live for today. You have to live for now." The past was behind a closed door. And I'd always thought of him as Austrian. I knew he'd lived in Vienna, where my mother had been born. I knew that he'd left in 1938, after the Anschluss and the arrival of the Nazis, and I thought that he'd left with my mother, who was an infant of just a few months, and that they'd gone to France. So the focus for me was always on Vienna and Austria, and never on the period beyond or before. But somewhere in one of the last conversations I had with my grandfather, he did talk about a place called Lemberg. And I remember telling him that one day I'd like to try and visit that place. I had no idea where it was. At some point I must have looked it up, learning that Lemberg did not exist anymore. Now it was called Lviv, and it was in the Ukraine. As I began to look into the history of that city, I learnt that in a period of 3 decades, up until 1945, it had been Austrian, then Russian, then Austrian again, then Polish, then Western Ukrainian, then Polish again, then Russian, then German, and then Ukrainian, all in the space of less than 30 years. It's a complex place that stands at many crossroads. I also recalled a conversation with my mentor, Hersch Lauterpacht, who told me that his father, Hersch Lauterpacht, had been born near Lemberg, but he had never visited the city, although he wanted to. And over the years, Ellie and I would often talk about visiting Lemberg, although I never quite knew where it was, with our families, but that never happened, and unfortunately he's now not well enough to permit it to happen. But last October I did go to Lviv, thanks to the introduction from Oksana. I went with my mother, my aunt, and my son. And she introduced me to a number of former colleagues in Lviv, and eventually, surprisingly, an invitation to give a lecture duly arrived. And so I immersed myself even more in this curious city, did some research, and learnt that it has many famous sons and daughters. But no one had apparently made the connection about some of these characters and their contribution to the modern system of international law. That contribution comes principally through the work of 3 remarkable lawyers, each of whom passed through the same law department of the same law faculty, the Jan Kazimierz University, now the Ivan Franko University, in the period between 1916 and 1939. If you were to visit the law faculty today, as I did, you would never know this. None of the lecturers, none of the students had any idea that these 3 men had been at their law school and had been taught in the same classroom. You know, with UCL, with Case Western, with Harvard, you have a half-famous person pass through the law school and there's a portrait or a bust or something. Lviv University has no reference to any of these people. So let me tell you a bit more about these three people. Let me begin with Louis Sohn. Louis Sohn I've already mentioned because, of course, David Kennedy was his successor at Harvard Law School. I first met Louis in 1987 at a meeting in Cairo. And in fact, the following year, I invited him to join the board of a new NGO that I was creating, the Centre for International Environmental Law. Amongst his many achievements, he had participated in the 1972 Stockholm Conference on the Human Environment, the moment when international environmental law really began. And he'd written a very fine article about that conference, the best article, in fact, in the Harvard International Law Journal. Following his death in June 2006, the Washington Post described him, and I'm quoting, as one of the world's greatest scholars of international law who helped draft the United Nations Charter, define international human rights, and design disarmament agreements. Right to the end of his life, he believed in the power of international law not only to shape state-to-state relations, but also to govern relations between individuals and legal entities. His most famous work was called World Peace Through World Law, and it advocated a system of world government. Louis Sohn believed in security through rules. And given what happened to him in the early years of his life, that is not surprising. Until preparing for that visit, I didn't know that Louis was born in Lemberg, as it then was, on the 1st of March 1914, when the city was still part of the Austro-Hungarian Empire. Those were years of unbelievable turmoil in insecurity. They make what we're going through today pale into insignificance. In his first year of life, he lived through a Russian occupation. That was then followed by a period of resumed Austro-Hungarian control until October 1918, and then for a few months, the declaration of a short-lived Western Ukrainian National Republic, of which Lviv was the capital, and then, for 2 decades, the resumption of the Polish-Ukrainian War and a Polish takeover in July 1919. By the time Louis Sohn was 6, he had lived under the rule of 4 different countries without ever setting foot outside the city in which he had been born. He lived through pogroms against the Jews, of which community he was a member. He lived through a Red Army siege in August 1920. So it's no surprise that his view of the world would be informed by these personal events. In 1935, he obtained degrees in science and law at the Jan Kazimierz University, staying on as a young academic researcher under extraordinarily difficult conditions. Despite the Polish Minorities Treaty of 1919, which committed Poland to respect the rights of all inhabitants of Poland without distinction of birth, nationality, language, race, or religion, as a Jew, Sohn was only allowed to gain illicit access to the library. He had to go in before it opened in the morning, and he could not be seen there while it was open, and then sneaked out at the end of the day when it closed after the evening. He left Poland, as it then was, in 1939, apparently on the very last boat to leave before the arrival of the Nazis. He made his way to Harvard, where he obtained a master's degree and then a doctorate. In 1945, he participated as a member of the US delegation in the San Francisco conference that led to the creation of the United Nations. He worked alongside Manley Hudson, the American judge at the Permanent Court of International Justice, with whom he'd worked and continued to work for many years. Louis Sohn actually drafted the statute of the International Court of Justice. From 1961 to 1981, just before I arrived, he taught international law at Harvard Law School, during which period he also served as a leading member of the US delegation to the 1982 UN Convention on the Law of the Sea. His key contribution to that convention was on the development of new mechanisms for compulsory dispute settlement, and without him, it's unlikely that Annex 7 of the 1982 Convention on the Law of the Sea, which is the source of so much of my work today, would ever have seen the light of day. Put simply, without his efforts, I would not be litigating cases for Bangladesh under the rules that he drafted. Sohn's time in Lvov overlapped with another famous international lawyer whom he only met, I believe, once he got to the United States. That lawyer was called Rafael Lemkin, and Rafael Lemkin was the father of the 1948 Genocide Convention that I've already mentioned. Lemkin was born in June 1900, so he was 14 years younger than Sohn, in a town called Bezvodne, which was then part of Imperial Russia. Now it's in Belarus. He was one of 3 children of a Jewish family. He arrived in Lvov in 1920, and he also entered the Jan Kazimierz University, where he studied philology. He too had witnessed terrible conflicts in the early years of his life between Germany, Russia, and Poland, and he was acutely aware of the cultural differences in and around the Lemberg community, and in particular, challenges and threats to minority communities. By then, he already spoke 9 languages, and his passionate belief was that language was the key to understanding cultures and nations. Soon after he enrolled, he switched to the study of law against the background of the assassination in Berlin in 1921 of a man called Talat Pasha, who was the Turkish Minister of the Interior, and a man said to be one of the main architects of the massacre of Armenians by the Turks. In the ensuing trial in Berlin of Sogomon Tehilrian, who was the alleged assassin of Talat Pasha, that attracted a huge amount of attention. In June 1921, the alleged assassin was acquitted by a Berlin court on grounds of insanity. And this led to a heated exchange between Lemkin and one of his professors at the Jan Kazimierz Law School, in the course of which Lemkin expressed the view that it was the Turkish minister, not the assassin, who should have been hauled before a court for the crime of mass murder. The professor was deeply unimpressed. There was no law under which to charge the Turkish minister. Lemkin records him in his diary as saying, the professor gave him an example. Let's take the case of a man who owns some chickens. He kills them. Why not? It's not your business. If you interfere, it's a trespass. Same with people. According to his unpublished autobiography, Lemkin dismissed the analogy in the following way. He writes, sovereignty cannot be conceived as the right to kill millions of innocent people. Other cases of the day also raised issues and plainly catalyzed Lemkin's interest in what he would go on to do. One concerned a fellow Jewish law student at his university, Mundik Steiger, who was convicted of trying to assassinate the president of Poland whilst on a visit to Lvov. Steiger was apparently saved from execution only after a Ukrainian nationalist confessed to the act of attempted assassination. Another trial of the moment related to the case in Paris of Samuel Schwarzbord for the assassination in 1926 of Simon Petluria, a leader of the Ukrainian nationalists, whom Schwarzbord considered to have been involved in the pogroms that killed his parents. You can see at that time there was considerable interest in these kinds of stories. Again, the Paris court freed Schwarzbord on the grounds of insanity. That was the context in which Lemkin became interested in these issues. He got a doctorate in law from the Jan Kazimierz University in 1926. He began his professional career as a prosecutor in the district court of Barajny and then moved to be a prosecutor in Warsaw. Simultaneously, he acted as secretary of the Committee on Codification of the Laws of the Polish Republic, and he turned his attention to the new subject of international crimes. In October 1933, at the Madrid meeting of the Fifth Conference for the Unification of Penal Law, he presented his ideas for the recognition of 2 new crimes in international law. The crime of barbarity, that's to say, outlawing exterminations by means of massacres, pogroms, or economic discrimination, and the second crime of vandalism, the destruction of cultural and artistic works. These are the forebears of what we call today genocide. It's not clear whether Lemkin actually attended the Madrid meeting, or rather put his views forward only in writing, because the Polish Minister of Justice took exception to his ideas. The context by then was the arrival of a new government headed by Adolf Hitler in Germany, and the Polish government's desire to seek rapprochement with the German government. By this point, however, Lemkin was already a player on the international circuit. In 1939, like Sohn, he fled Poland. He arrived here in the United States in 1941 after journeying through various parts of Europe. He settled in North Carolina and he taught law at Duke University. In 1944, the Carnegie Endowment for International Peace published his most famous work, which is called Axis Rule in Occupied Europe, which detailed Nazi crimes throughout Europe. This was the first ever book to use the word genocide, and apparently it was coined by Lemkin after he heard Winston Churchill refer to Nazi atrocities as a crime without a name. Genocide is derived from the Greek word genos, which means race or clan, and the Latin suffix side, which means killing. Axis Rule, Lemkin's book, was deeply influential and referred to as the most talked about work in the corridors of the Nuremberg court in 1945 and 1946. At Nuremberg, Lemkin served as advisor to the chief prosecutor, Justice Robert Jackson. He was deeply disappointed that in the end, reference was made to genocide only in individual indictments and not in the findings of liability, and that overall preference was given to a different concept, the notion of crimes against humanity. The crucial difference being that crimes against humanity didn't require any proof that the atrocity had been committed against a particular group. That's the essential difference. Lemkin devoted the rest of his life to this issue, to the prohibition of genocide, described, as we now know, as the intent to destroy in whole or in part a national, ethnical, racial or religious group as such. He became, someone put it, a permanent fixture at the fledgling United Nations organization, where he walked the corridors, prodding and persuading hesitant delegates. He personally wrote the entire initial draft of the Genocide Convention. And during the days of intense lobbying in the 1940s that followed at the UN, he was seen as a dreamer, a fanatic, a fantasist, an exceedingly patient man, and, as one person put it, a totally unofficial man. In 1948, remarkably, his convention was adopted. It was written that when the UN General Assembly approved the convention on the 9th of December 1948, reporters who went looking for him to share in his triumph found him in a darkened assembly hall, weeping in solitude. The remaining years of his life were devoted to the implementation of the 1948 convention, which contained enforcement mechanisms allowing for recourse to the International Court of Justice. Of course, it was these same provisions that were relied upon by Bosnia in 1993, by Croatia in 1999. On account of a recent biography, Lemkin's later life seems not to have been a happy one. He taught at Yale, he taught at Rutgers in New York, he lobbied actively on the implementation of the convention, and he died in August 1959 in New York City. He never married, he had no children, and only 7 people attended his funeral. Lemkin never lived to see the full recognition of his role in developing the Genocide Convention, which is plainly a landmark of modern international law. Of his various disappointments, none seem to have been greater than the fact that little was made of his concept of genocide at the Nuremberg trials. As I've mentioned, far greater prominence was given to the concept of crimes against humanity, a term that then, but not now, related to crimes during times of war. The focus on crimes against humanity, as it was then described, meant that the Allies could exclude the events of the 1930s in Germany before war began. That term, amazingly, crime against humanity, emanated from the mind of another son of Lemberg, Hersch Lauterpacht. For it was Hersch Lauterpacht who formulated the definition of the crimes that were to be enshrined in Article 6 of the Nuremberg Charter. He too, of course, was very closely connected with Lviv and he happened to be the father of my mentor, Hersch Lauterpacht. And you can imagine the scene that at Nuremberg you've got these two guys who don't get on, who are battling it out for what the heart of that convention is going to be. Hersch Lauterpacht was born in 1897 in Zolkiev, a town that I mentioned before, just a few miles from Lviv. Into a middle-class Jewish family, he was the second of three children. In 1910, his family moved to a six-room apartment in Lviv so that he could attend a better quality of secondary school, the Humanist Gymnasium, where he was said to have been a brilliant student. In 1915, at the outset of the First World War, he was conscripted into the Austrian army. In fact, he served at the timber yard run by his father. At some point in 1915, he began to study law at the Jan Kazimierz University, which he continued to attend for 8 semesters. It's never been clear whether he actually obtained a degree for the university. In 1920, he wrote a letter explaining that he'd not been able to take the final examination because the university had been closed to Jews in eastern Galicia. However, a certificate has since been found, issued by the University of Lvov in April 1917, stating that he took at least some exams and that he'd passed with a good result. Whether it actually led to graduation from the university is unclear. During that period, he became very active in the Jewish student movement, and in 1917 he organized a demonstration to celebrate the publication of the Balfour Declaration, a notable act at the time, given that at that moment Austria was at war with Britain. In 1918, at the end of the First World War, a conflict arose in Galicia between Poles and Ukrainians, and the Versailles Peace Committee sent a commission to decide on the frontier of those countries. This committee was known as the Curzon Committee, and it selected Lauterpacht, who was then 21 years old, as an interpreter on the basis that he could speak all the languages and he knew the territory. In 1919, he moved to Vienna to enter the university, where he studied with Hans Kelsen. By then, he was already angered by social inequality, he was opposed to chauvinism, and he dreamt of what he called a Jewish Renaissance based on the spirit of social justice. His writings, even at that time, are said to have displayed a vast culture, an extraordinarily powerful style, and clarity of thinking and exposition of ideas. He never again lived in Lvov, although he did return for 2 short visits. On one occasion, in 1928, this coincided with a conference on international law in Warsaw. By then, he was already a member of the British group, and having moved to Britain in 1923, was studying at the LSE. During the conference banquet, he spoke in English and in Polish, as a result of which he was approached by the Chief Justice of Poland, who asked, "How comes it that you speak such good Polish, and how comes it that you come from England?" The reply, Lauterpacht said, was, "Thanks to your numerus clausus," the law that prohibited certain numbers of Jews from studying at the university. In Vienna, he obtained a Doctor of Laws and a Doctor of Political Studies, met his wife, who was studying the piano. They moved to London in 1923. Lauterpacht attended the London School of Economics as a research student, studied with Dr. Arnold McNair, who became a mentor and a friend, and in 1928 his only child, Ellie, was born. He taught at the LSE until 1937, when he became Whewell Professor of International Law at the University of Cambridge. And in 1954, he emerged as a candidate for election to the International Court of Justice, nominated, rather amazingly, by the United Kingdom. He attracted support from the Minister of State, Selwyn Lloyd, who wrote to the Lord Chancellor, Lord Simons, on the 25th of July 1954, that his nomination would meet with universal approval internationally and would be the best and the right thing. But Lauterpacht was an immigrant, and as such his nomination raised concerns in the highest quarters. The Attorney General, Sir Lionel Heald, was concerned that Lauterpacht's nomination would be badly received by the legal profession and the House of Commons. I came across a wonderful old letter that Attorney General wrote, in which he says the following: "It is surely desirable," writes the Attorney General, "that our representative at The Hague should both be and be seen to be thoroughly British, whereas Lauterpacht cannot help the fact that he does not qualify in this way either by birth, by name, or by education." The objection came too late. The nomination had already been made, and Lauterpacht was elected to the World Court in October 1954, where he served with great distinction, but only for a short period of time. He died in 1960 of cancer. Lauterpacht's writings and activities are simply too numerous for me to begin to summarize in a short lecture like this, and many of his works are still consulted today and referred to in judgments around the world in national and international courts. But at the heart of his approach, and he is surely the great international lawyer of the 20th century, is a belief that international law is a translation of natural decency, rationality, and universal values into its professional language. This is an approach based on principles of what he called legal normatism, legal completeness, and absolute justice, so that the system of international law is complete, is pluralistic, and is liberal cosmopolitan. And it's these themes that emerge consistently in his writings. From his doctoral thesis on private law sources and analogies of international law, published in 1927, through to his famous book, The Function of Law in the International Community, and, even more significantly, his book, An International Bill of Rights, the book that directly and immediately influenced the text of what became the 1950 European Convention on Human Rights, first ever regional human rights instrument. Unusually for the times, Lauterpacht was also uniquely interested in the practical side. He edited a well-known publication called the Annual Digest of International Law, now known as the International Law Reports, and was called to the English bar in 1935. He appeared as counsel for the United Kingdom in 2 cases at the ICJ. Just as Rafael Lemkin advised Justice Robert Jackson at Nuremberg, Lauterpacht was his counterpart in advising Hartley Shawcross, the chief British prosecutor. In fact, it was Lauterpacht who drafted most of the first drafts of the opening and closing speeches of the chief British prosecutor, Hartley Shawcross. At the end of those trials, Shawcross wrote to him, "I hope you will always have the satisfaction in having had this leading hand in something that may have an influence on the future conduct of international relations." Through the turmoil and grief of the 1930s and 1940s, Lauterpacht had remained dedicated to the rule of law and promoted the protection of human rights for all. He advocated for the imposition of individual criminal responsibility under international law. He prevailed over the counter-argument that only states could incur liability under international law. But for his academic writings, it is not clear that that vital change would have been made, and he argued for the recognition and prosecution of international crimes, including against heads of state. He contributed powerfully, directly, to the most important trends of the modern system of international law, and it's simply impossible to overstate the significant intellectual role he played in the modern system of international law in which we now all live. Following his death, Lord McNair, who had been his mentor in Britain, wrote that his prominence and success were due to his passion for justice, his devotion to the relief of suffering, his transparent sincerity, and his gifts of persuasion, both in writing and in speech. So as I draw to a conclusion, let me pull together the threads of this lecture. It will not have escaped your attention that what I've said up to this point touches upon, but hardly investigates, a great number of issues of considerable complexity. Zolkiev, Lauterpacht, international criminal law, Lemkin, the human rights of individuals, the new international courts, Louis Sohn. What are the connections? What is this story all about? Now, some of you, listening carefully, may have worked out a connection. I, of course, have a professional interest in these matters, in the circumstances in which new rules of international law emerged in the aftermath of the terrible brutalities and atrocities of the period around the Second World War. Rules reflected in texts like the Atlantic Charter of 1941, the UN Charter of 1945, the Nuremberg Charter of 1945, the Universal Declaration of Human Rights of 1948, the Genocide Convention of 1948. These transformed the world, transformed the global legal order. And these were the instruments that reflected the aspirations and endeavours of Sohn and Lemkin and Lauterpacht whose intellectual efforts and practical efforts contributed directly and substantially to the modern system of human rights and international criminal laws with which Case Western Reserve Law School is now so very closely committed, including, of course, through the vital work of the Frederick Cox International Law Centre. It would be odd indeed, given my interest, if I was not interested in the people who made these new rules, designed to fill the gaps left by the patent inadequacies of earlier treaties like the 1919 Polish Minorities Agreement that did not protect the rights of Louis Sohn in Lvov. It would be odd if I were not to note their common connection to that city and to speculate as to how their personal experiences would have informed their intellectual inquiries and their professional activities. And it would be odd, too, to conclude that these factors might be entirely unconnected, whether by the air and atmosphere of a remarkably cultured intellectual city or by the collective or individual experience of unimaginable abuse and atrocity. But there's another reason that I'm interested, which I touched on earlier, and it's this. The invitation, of course, to go to Lviv provided me with a first opportunity to visit the birthplace of my own grandfather, who'd been born in Lemberg in May 1904, when it was Eastern Galicia, part of the Austro-Hungarian Empire. My grandfather, Maurice Buchholz, was the youngest of 4 children, and at the time of his birth, his parents lived at number 12 Sheptic Street, a building that still stands and that I visited last October, the first family visit back in more than 80 years. His mother, Malka, was born in 1870 in Zolkiev, in the same place as Elie Lauterpacht's father, Hersch Lauterpacht. And I also visited Zolkiev, including an opportunity to enter the dilapidated ruins of what was apparently one of the great synagogues and temples of Central Europe. As far as I've been able to work out, my family remained in Lemberg until 1914 or 1915. My grandfather then left for Vienna with his parents and his 2 sisters, and the cause of their departure was the death of my grandfather's oldest brother, who'd been conscripted into the Austrian army and was killed early on in the early days of the First World War. I, in fact, had always thought then that he'd never returned, but recently I found amongst his papers a Polish passport in his name dating to 1923, which seems to have been issued in Lvov and issued to him personally. Thereafter, he did not return to the city, although it seems he never forgot it. Having by now done all this research on Lauterpacht and Lemkin and Sohn, I was particularly pleased when Elie then made the introduction for me with his relative Inka Katz in Paris. That's the visit to which I described at the beginning of this lecture. Inka was Hersch Lauterpacht's niece. She was the only member of that part of his family that remained in Poland and in Lvov who survived the Holocaust. 49 out of 50 members of Hersch Lauterpacht's family were killed. And actually, if you want to read a remarkable account of these times, I commend to you a book by another remarkable lawyer, Louis Begley, who is a retired partner of the international law firm of Debevoise and Plimpton. His book is called Wartime Lies, and it is a fictionalized memoir of a child's survival in Lvov. It's published as a Penguin Modern Classic, and he too grew up in Lvov and describes his experiences as a 9-year-old. I did visit Inka, and of course she told me her remarkable story of survival with maps spread out on her dining room table, described to me with perfect recall her childhood, and showed me on the maps where she had grown up and lived on Technica Street, just around the corner from where the Lauterpachts and her uncle Hersch lived as a young child, number 64 Petra Doroshenka Street. And then she showed me on the map where my grandfather had lived during the same period, and it turned out it was less than 200 yards from where the Lauterpachts had lived. Last October, I visited all of those addresses. They are remarkably close to each other. Walking the streets, I imagined the possibility that whilst the 2 families would not have known each other socially, since they occupied different levels of society, shall we say, the Lauterpachts were professionals, my great-grandfather was merely an innkeeper, they may well have crossed each other in the streets in the weeks before the outbreak of the First World War, or perhaps when the Russians were in occupation in early 1915. I wondered, of course, whether any of the Lauterpachts would ever even have visited the restaurant. I doubt, however, that my grandfather could ever have imagined another possibility, that 7 decades later, in the 1980s, sitting in a small apartment 1 floor above the Grolier Poetry Bookstore in Cambridge, Massachusetts, an English grandson of his would receive a letter from the son of his Lemberg neighbour inviting him to take up a first academic position for the study of international law at Cambridge, an invitation that would eventually lead me to be with you today. When Louis Lauterpacht identified me as a candidate for the post, he had no idea about our geographical and historical connection. It's really only in the past few weeks that I've discovered it and have shared it with him. So it's difficult to know what precisely would have caused different individuals from that post-First World War generation of Jews in Lemberg to take up the cause of international law and to seek to remake the field in a new image. Apart from their connection with Lemberg or Lvov, the individuals I've written about shared other aspects of life. They suffered the great loss of all of their family members. Sohn and Lemkin lost their parents and many other family members. Lauterpacht's parents were murdered in Belzec or Lvov in 1943, the only family member to survive being Inka Katz, who was saved as a 12-year-old girl who lived on the streets of the town for 6 months, as she described to me, saved by a community of nuns who took her in, baptized her, and protected her until the Nazis had left. My own grandfather lost his mother, who was murdered in Treblinka in 1942, and his sisters. His father had already died. It's really not too difficult to see how these terrible events would have contributed to an instinct for justice and for the rule of law, even if it's plain from the accounts I've given that such instincts were already in place in the writings of Lauterpacht, for example, well before the horror took place. And one can also speculate about how these 3 men would react to the world of international law today, which, despite its numerous enhancements, still suffers from many of the same limitations that characterized the 1920s and the 1930s. Ask the Christian community in Baghdad today whether it feels protected by the international norms that are now in place. Ask the Palestinians in Gaza whether they feel protected by the international norms now in place. Ask the detainees of Guantanamo or the citizens of Chechnya what effect these norms have had for them. Nor can I know for certain what might have caused the same instincts to be kindled in someone like me 2 generations later. We know, of course, that the memory of events occurring to one's own family can give rise to a thirst for vengeance, a sort of terrible sins of the fathers hatred. We've seen that in the Balkans, we've seen that in Rwanda. But there are other ways, as these 3 stories that I've described to you set out, and the instinct to justice under a rule of law is one of those alternatives. And that's the principal lesson that I draw from the experience of these remarkable men from Lviv, whose efforts remind us that the challenges we face today are neither new nor insurmountable. The international rule of law imagined by Lauterpacht, by Lemkin, by Sohn, is as vital and important today as it was in 1945. It ought to inspire all victims of abuse and illegality, irrespective of creed, nationality, of race, or of religion. And it ought to be a route for which the whole community in Lviv might feel some pride. One would have thought they might honour the possibility of moving forward in a spirit of justice rather than backwards in a spirit of vengeance. Whatever the causes of my own direction and how I got to do what I do, one thing seems to me very clear. Lviv, or Lvov, or Lemberg has made a remarkable and singular contribution to the creation and application of the modern international legal order. The city's DNA is impregnated into the modern international legal order. That could be a cause for pride and even of celebration, even if it is not yet recorded in the city. I would hope that that city's contribution and that of these pioneering international lawyers might one day be embraced by modern Lviv. Such an act would pay tribute to memory and to justice. Let me conclude by thanking you very much for your kind attention and also record again my appreciation to the organisers of the Klatsky Seminar on Human Rights and the invitation to be here with you today, and to everyone who helped make this visit possible. Thank you very much.
So we invite you all to join us in the rotunda right behind us, where we will be celebrating the whole area of human rights and our Klatsky lecturer, Philippe Sands. Please join me again in thanking him today.